Further hearing in the appeal, Scotch Whisky Association and others, and the Lord Advocate and another.
Lord Advocate. Thank you, my Lord. My Lady, my Lords. I should pick up on some questions and points from yesterday before resuming, if I may. First of all, my Lord Mance asked me about the material which was before the lower courts. There's a document among the papers, it's tab 29 in volume 1, which contains the inventories of productions which were before the Lord Ordinary, and also the appendices of documents that were before the Inner House.
Yes.
And I should say, my Lord, that in my written case, I've effectively replicated the submissions which were made before the Inner House, but with the references directly to this court's bundle.
Yes.
My Lord, Mance also, if I might pick up on the discussion yesterday about the statistics which appeared in the work done by Sheffield University which I think had been referred to in the reference by the lower court to the Court of Justice at paragraphs 15 and following. These are statistics at MS 0396 and following.
0396.
MS 0396 and following.
Right.
And they're based on work which had been done by Sheffield University. And it's my understanding, I'll be corrected if I'm wrong, that what was before the extra division, which made the reference, was the presentation which the court was shown yesterday, which was at MS 4887. And it's really just to make the point that that looks at a 45 pence.
Sorry, what was the reference? MS
4887.
887.
It was a slide presentation that the court was taken to in the course of yesterday.
Yeah.
And I'm really just making the point that that's a document which looked at a 45 pence minimum unit price for England. And I've already made the submission that this is not a context where it is appropriate to assume that data for England and Wales are applicable in Scotland. I mentioned yesterday the data in the BRIA, which disclosed that statistics for consumption and alcohol-related harm in Scotland are different. And I also referred to paragraph 4.42 of my written case, where under reference to documents, I made the point about the particular problem in Scotland relating to cheap vodka. And the point can be demonstrated by the reference to the Sheffield paper, which is at tab 22 in volume 4, at MS 0959. This is a paper which is also concerned with the position in England and which sought to model a target in terms of a reduction in whole population mortality of 4.3%, which was the reduction which, according to that paper, would be achieved in England by a 50 pence per unit minimum unit price. And the court can see that at MS 0962. Yes. It's 0962, just in the middle of the page. Essentially what was taken was the 50 pence minimum unit price. The paper identified the reduction in whole population mortality, which would be achieved by that at 4.3%, and then modelled other ways of seeking to achieve that. The short point I make, my lords and my lady, is that in Scotland, the Sheffield April 2016 paper, a few months later, predicted that the same minimum unit price would achieve a 7.4% reduction in mortality across the population. And that's at MS 1046. And that, I suppose, emphasises not only the need to attend closely to using the right data, but also incidentally illustrates the particular problem that Scotland has in relation to the consumption of cheap alcohol.
Yes. Yes.
Yes, I think it's been suggested, quite rightly, that I should take the court to MS 1046, to table 4.11. And just show the court where the 7.4% figure comes from. It's in table 4.11, under the column policy impact on deaths per year, full effect, total. And one goes down to relative change against 50 pence minimum unit price. One finds 7.4%. Now, I should say that in the BRIA, at the time of the BRIA, the modelling suggested a figure of 17%. That's at paragraph 5.20, MS 0864. And I'm told that that is a shift that reflects effectively the change in the, or principally the change in the shift in the market.
Sorry,
In the sense that I'm told that as it were, the market has shifted towards more, in a more expensive direction overall.
I see. So there's less impact by a minimum price.
There's less impact by minimum pricing.
But that's in how long a period? What about?
That was the BRIA was
4
in
years.
2012.
Yes, correct.
I don't have a date for the modelling that was done before that, and
the other 2016. So in 4 years.
yeah. It's MS 0864. I should also say that there will require to be an updated BRIA if this appeal is refused when and the order is presented to the Scottish Parliament.
So presumably.
Yep.
Well, that will be part of an assessment of both sides of the equation, will it? The impact on the market as well as the impact on mortality and health.
It'll be a business regulatory impact assessment, and my Lord can see the nature of that document.
So we could have this litigation all over again, could we?
Well, one hopes not, but
in theory, I mean, if it's a new base, presumably. I mean, one of the points which you have to deal with, in my eyes, at any rate, is how we approach the fact that your basic answer to the market impact is it's unknowable, whereas there's some quite trenchant reports by Yarrow and Decker who say that it's not unknowable in the sense that it's quite clear there's going to be extreme distortion, they say.
But my short answer to that, my Lord, is that if it is correct, if the judgment that's been made that alternative measures cannot achieve the aim effectively or as effectively as minimum unit pricing, then one doesn't get to distortion of the market.
Yes,
and-
but how far off are the alternative measures is then the question that arises, because, I mean, it's suggested that the alternative measures can achieve the same overall effect, but not targeting quite the same segment of the population, and that's what I need to have clarified.
But my Lord is absolutely right. The absolutely critical short issue in this case, I would suggest, is the correct characterisation of the aim.
Yeah.
My learned friend takes, and I don't use this adjective in a pejorative sense, he takes a relative reductive approach to the aim. I say the aim is, as agreed and read in the context of the policy as I sought to explain it yesterday in the policy documents, is an aim which is targeted, as it has as its primary target, those hazardous and harmful drinkers who are most at risk of alcohol-related harm.
Although they're only a small percentage, are responsible for a very large percentage of the actual
Indeed.
consumption and cost.
Indeed. The point about this policy is that it has been rigorously driven by a focus on where the greatest harm caused by excessive alcohol consumption is, and how that can be effectively addressed in a way which targets those who are most at risk, recognizing that in targeting those who are most at risk, there will also be people in the general population whose consumption will be affected and who will benefit. And I say one doesn't read the aim just as a sort of formula on the page. One reads the aim in the context of the policy that it's intended to pursue. And one then asks, is the judgment that's been made explained as it is in the BRIA and the policy memorandum that an increase in tax can't achieve that aim or can't achieve it as effectively? Is that a judgment that was within the margin of appreciation available to the legislature?
I mean, it seems pretty clear that if you increase taxes enough, you will achieve an equivalent reduction in consumption by the target groups. As a matter of principle, it may be difficult to work out how much is enough.
I don't dispute that, my
Yes.
Lord. Indeed, the Sheffield study demonstrates that.
Well, I mean, as a matter of common sense, it must be so. There are both mechanisms for increasing prices. But in those circumstances, the critical question may well be, what is the relevance, if any, of the impact on people who are only marginally targeted, but may be very considerably affected by a tax rise as opposed to a minimum price? Now, in that context, I would welcome at some stage your analysis of what conclusions we ought to draw from paragraphs 47 and 48 of the CJEU judgment, which are the paragraphs that address that question. I have to say, from my own point of view, rather obscurely, but they may well be paragraphs which are critical to the outcome of this appeal.
I absolutely see that, my Lord. And perhaps I'll make the short submission now, which is that the alternative measure, the option that my Lord has postulated, in which one can see from the Sheffield study of increasing taxes to the level that would achieve, at least in numerical terms, the same effect. That option is not rejected because it would provide greater benefit in health terms than minimum unit pricing. It's rejected essentially because it doesn't, because it disproportionately affects a part of the population which is not the primary target. Secondly, because it doesn't respect the But secondly, because the alternative option doesn't respect the balance which the legislature has deliberately sought to achieve here between targeting those most at risk and not disproportionately affecting the broader population.
It's the same point, isn't it?
It's really the same point, but put in a slightly different way.
Sounds-
I mean, basically, you're saying it's, perhaps this is an unfortunate simile, because it's the wrong way around, but overkill.
Yes.
The marginal benefit on the rest of the population is achieved by grossly disproportionately increasing prices for them.
Yes, but I do say that what it all comes back to is a recognition of the policy focus that underpins the targeted aim and the deliberate balance that the legislature has sought to strike between focusing on those who are most at harm and not disproportionately affecting moderate drinkers. And these are the reasons why the alternatives are rejected, not because, not because...
No, amongst the advantages. I mean, that's a very strange argument which the court seems to have picked up and run with.
Indeed. Yes, and I say in those circumstances, really, paragraphs 47 and 48 really don't they're aiming at they're not directed at the position that I'm advancing.
I understand it also, you say that increasing taxation can lead to internal adjustments which within the selling with retailers and within the producers, which minimum pricing can't be played around with.
Indeed, my lord. I mean, I'm taking, as it were, the high-level point. There is also the point that minimum unit pricing is straightforward. It's not susceptible to
manipulation.
Either manipulation on the one hand,
I think
or trading down. Although I do accept, can I say, I do accept that one could again set duties at a level combined with a requirement to sell at a price no lower than a combination of duty plus VAT. One could achieve the effect of a floor, but again, at the cost of a disproportionate impact on the market as a whole.
You're putting things a bit high to say that minimum pricing is not likely to lead to distortions. I mean, it's pointed out in the analyses that it's highly likely to lead retailers to focus on promoting the cheap materials which now have a higher minimum price on which they're making a bigger margin, and it's quite and they will stop selling the low margin materials which are anyway priced at just above the minimum price. They're going to be I mean, on the analyses, obvious and rather large distortions in the market.
Can I say I don't dispute for a moment this will have an impact on the market.
Yeah.
I suppose three things. One is precisely what those effects will be is a matter of uncertainty, although my lord is right, one can predict certain things, and that's looked at in some detail in the brief.
Unless you'll get troops of no doubt foreign importers over here saying we deserve a cut on the increased price, so there'll be all sorts of knock-on effects.
Well, there will. But the second point to make is this: that if this is a measure which is properly justified on health grounds, then the fact that it has distortive effects on the market is nevertheless justified.
Don't you have to consider how distorted they are?
The Court of Justice says in terms that a policy which undermines the CMO, the objects of the CMO, may nevertheless be justified in accordance with the normal.
Yes.
Normal
well, I think
rules.
we accept that, but don't you have to assess how undermining it is? I mean, if it has a marginal effect on one Italian importer or Spanish importer, that may be different from the fact if it has if it leads Tesco to favour their own brand because they can be certain of making the extra profit over the other Italian importers who they use and so on.
I'm about to go back to the data on wine that I left last night, my lord, but just perhaps the third point on this particular issue is to remind the court that this legislation has been explicitly introduced, recognising uncertainties as an experimental piece of legislation, with obligations on the government to evaluate and review it after a period of 5 years, and indeed with a sunset clause so that it will expire unless renewed at the end of 6 years. And that's an important, in my submission, that's an important part, and it's something the Court of Justice recognised as a legitimate part of the consideration here, because there are of course uncertainties. There are uncertainties in how consumers will respond. Work has been done to try and predict how consumers will respond and to anticipate the benefits. But of course, there are some uncertainties there. As far as how the market responds, again, the BRIA sets out a number of quite a lot of information based on the consultation and other information available, looking at the market impact. But it's recognised in the BRIA itself that there are areas of uncertainty. So in considering whether this is a proportionate measure, the explicit obligation to evaluate and review and the sunset clause are, in my submission, important parts of the overall balance.
It didn't count for very much in relation to, I think I forget whether I'm referring to, I think I'm referring to the insurance, the permission to continue to look at sex in terms of insurance premiums, which I think was subject to a review clause. And when they went to the ECJ, they said they weren't having any of that. They just made up their mind that this was disproportionate.
Well, what's striking in this case is that the CJU, in its judgment, tells us that that's a consideration. Perhaps I should just draw the court's attention to that. It's paragraph 57. It's not in the ruling itself, but in the reasoning at 57 at MS 0339.
339.
Where we're told the court tells us that the referring court may take into consideration the possible existence of scientific uncertainty about the effects on consumption of alcohol of a measure, and then the fact the legislation provides that the setting of an MPU will expire 6 years after the entry into force is a factor that may be taken into consideration. So if my lord needs some comfort that in this case that's an acceptable consideration, it's there. Yes. And it endorses the Advocate General's point at paragraph 85, which is at MS 0368, where he likewise says that the somewhat experimental or fixed-term nature of the rules is a factor to be taken into consideration by the National Court, since it seems to establish in advance that the rules will be revised in the event that the reasons that led to their adoption have changed. And of course, as my Lord Mance has observed, any order made by the Scottish Parliament continuing the legislation in force, if this appeal were, if we get there, would be susceptible to assessment in light and potentially legal assessment in light of the evaluation and the review that underpins it. I'll come to the data about wine, if I may, in just a minute. But since I had paper 22 in front of me, I'll just remind the court that this was the paper from which my learned friend took a volumetric tax of 22 pence a unit for all beverage types as a possible alternative. And just to make the point that the current excise duty on spirits is over 28 pence a unit for a country with a particular problem with cheap vodka. The proposition that excise duty on spirits should be reduced as a substitute for the measure before the court is perhaps unpersuasive. So if I could just look at the data about wine, and this perhaps goes to the point that my Lord Mance has raised. I say we don't get to having to consider market impact if the judgment about the alternatives is well-founded. But as it happens, there is data about wine. And if I could start with the BRIA at MS 0882,
Is that proposition right, though? I mean, if you have a legitimate aim, which can't be fulfilled by some other way, in some other way, then do you avoid any consideration of whether the harm involved to some other principle like freedom of movement is makes the overall exercise disproportionate? I wouldn't have thought you did. Isn't that a requirement in any event? I mean, you may have a legitimate aim and you may only be able to achieve it in one way, but the damage you do to some other principle may outweigh the legitimacy of the aim.
I suppose this really comes to the question of whether there's an ultimate balancing exercise to be
Yes, that's what I was suggesting, yes.
My short submission on that is that in the context of this aim, in this case, with a measure that is anticipated to save 2,000 lives and more.
Well, you say that the aim is so important that
health
almost any detriment.
Health and life, as we know, is one of the highest objects of union law.
Yeah.
And so I say, if that balance does have to be undertaken, then that object, and also lives saved, more than 38,000 alcohol-related hospital admissions avoided. But as it happens, the court did conclude that the impact of the measure on EU trade would be relatively minor.
Where's that?
That's at paragraph 203, MS 0319. And I'm about to show the court the data on wine, which, in my submission, entitled the court below to express that view. And if I could look first at 0882. At 5.72, and I should say this isn't focused on...
Which page was that?
It's MS 0882, my lord.
882, thank you, sir.
At paragraph 5.72.
What is this in?
It's in the BRIA.
Oh, in the BRIA. Thank you.
And I should say this is not a statistic relating to cross-border trade, but it's a statistic about the sales of wine across the board. At a minimum price of 50 pence per unit, the modelling estimates a small decrease in wine sold as off sales and a marginal increase in on sales. Using similar methodology, the decrease in off sales wine is estimated to be around 3%. That, of course, is wine from all sources, both EU and non-EU.
When it says plus a discount ban, what is that adding to a minimum price? Discount for bulk or something? Or? I thought we had that already.
I think there was under consideration a proposal to ban retailers offering discounts, discounted alcohol, along with the minimum price.
I would have thought that.
Right, okay. Okay. My friend Mr. Moynihan tells me that particular discounting measures, three for the price of two type discounts have been prohibited, but not all discounting. Right. Yes.
I mean, it's a huge change from 3% to 8%, so obviously this is pretty significant discounting. I haven't quite understood what it is.
Well, it perhaps makes the point about that retailers use alcohol
Quite.
in a particular way, or may do so.
Anyway.
In the present context, I'd suggest that the appropriate figure is the 3%. So that's trade in wine from all sources, EU and non-EU. And Table 14, which is as 0896, identifies, albeit only for at that time the data was available only for the UK market, the sources by country of the top 10 selling wines.
I'm sorry, one sees actually in the next paragraph, 573, there's a discussion of an actual discount ban imposed under the same legislation, which was to do with bulk selling of bottles of wine at reduced prices.
Yes.
And that's apparently a ban on that in force.
Yeah. Yes. If one reads through that to the end, one sees that retailers may still reduce prices, in effect, to achieve the effect of a discount. So, which is why I say the 3% is the correct figure. Can I just make this short point before I look at some other data, which is that reliance on aggregate market impact is sufficient to show that the legislature weighed up the economic consequences of the measure, and in particular in this context, that it addressed the impact on the wine market, which is of course particularly relevant for the CMO. And just by way of illustration, in the bundle, the court has the Philip Morris case at tab 60, and at paragraphs 189 to 190, MS 3831, one sees that point being made. It's a pretty obvious point that if one has an impact assessment that tells you that there's going to be a particular impact on the market, then you can conclude that the decision maker weighed up the consequences. Yes, it was a tobacco packaging case, the Philip Morris one. It was MS 3831, paragraphs 189 to 90.
Forgive me, Lord Advocate, I'm having great difficulty in hearing you.
I do
I'm
beg-
sure that those behind you have even more difficulty.
I
So
beg my lady's
would you mind
pardon.
speaking up?
I will do. I'm sorry.
Please.
I'm conscious that I sometimes speak rather quietly.
Yes, it's a help if both microphones are on and you're speaking into them, but even so, it's even better if you actually project your voice a little bit more.
Thank you, my lady.
Could you repeat the paragraph? It's something to 190, I think you said.
189 to 190.
189.
189 to 90. 189 simply shows the figure, and then 190 is the comment by the court. And I should say I'm focusing on wine for two reasons. One is that obviously wine is the product that is relevant for CMO purposes. But also there is evidence, in fact it's in the Yarrow and Decker, said in the Yarrow and Decker report at MS 1099, that in terms of relative trade impacts, the largest category averaged effects appear to be in relation to wine. So wine, if one looks at wine in one, it's useful in both senses. That's at MS 1099, explained by them at MS 1121. So the starting point is a relatively small decrease in wine sold across the market of 3%. And I should say that the Sheffield April 2016 study predicts that a 50 pence minimum unit price will result in a reduction in consumption across all categories. It's not disaggregated, but across all categories of 3.5%. And one can see that at conclusion M6 at MS 0996. And then it's against the background of those aggregate reductions in consumption that one can look at the data that we now have specific to Scotland in relation to wine. And there are two sets of data in the papers. There's the data set that was relied on for the purposes of the reference to the Court of Justice, which were derived from a document at tab 47, MS 4915. But there's then updated information, which is, I think, where my learned friend's table in his case was derived from, at tab 48, MS 4934. And I think these are figures from 2013. And these were the latest figures when the case was before the First Division. And if I could take the court to that.
4934. Yeah.
4934.
Yep. Yes.
And what the court sees is a table which shows the volume of wine from different countries of origin sold off trade in Scotland 2013. One sees in the third column the percentage of the total off-trade wine sales from that country, and then one sees the percentage of country of origin wines sold below the price threshold.
So where does one see that?
The last four columns.
If my Lord Mance looks at the third last column,
Yes.
That's
below 50p per unit, one sees the percentage. So if one goes down, the largest EU country is Italy, with 12.6 of the total off-trade sale in wine. 31% of that 12.6% is sold below 50 pence a unit. And one can follow that table down all the way ultimately to England, which has less than 0.1% of the sales, of which none is sold below 50 pence a unit. And Romania above that at 0.1% of the total trade, of which 84% is sold below the 50 pence a unit. So there's data in that data set, but that has, of course, to be set in the context of an anticipated reduction in consumption. The BRIA said 3% in wine. The most up-to-date information says 3.5% across all categories, because, of course, although all wines sold below 50 pence a unit would now, if this measure came in, have to be sold at 50 pence a unit, that doesn't mean that it will disappear from the market.
Actually, it's Spain which is the most affected, isn't it? Because it has the highest percentages of cheap
Yes.
wine.
Yes, with 10% of the market and a little over half, 56%, being sold below the 50 pence a unit. So there will undoubtedly be an impact, but in terms of the impact on trade, one has to bear in mind that the mere fact that the price will go up, I mean, let's say one has a bottle of wine that's been sold at 45 pence a unit, now being sold at 50 pence a unit, that may well still be purchased at that price, particularly because there won't be cheaper wine on the market. So I think I would submit that one has to understand this table in the context of the anticipated drop in consumption and the BRIA.
Have they allowed in the calculations for the fact that supermarkets are likely to promote these wines on which they have higher margins by putting them in prominent places and so on?
Well, it really illustrates the difficulty of prediction in this area. One of course can anticipate there will be impacts, but the point that my Lord Mance makes is I suppose takes one to this, that the low-cost producer doesn't lose his competitive advantage on the wholesale trade. Now, the fact that at the retail end there's a 50 pence minimum unit price may well affect the market, but precisely how that will feed through is something that one...
In principle, as a matter of economics, the higher the profit margin of the retailer, the higher the bargaining power of the producer who sells to the retailer, so that one would expect the additional benefit to be shared in uncertain proportions between them.
Indeed, my Lord. But I come back to the BRIA point that we're talking about a drop in the wine market sales of 3% as a result of this measure. Could you find that? There's just one other piece of information that was before the Inner House on the wine market. It's Table 4, which is at MS 0181. 0181. It's in the written case. And I just draw attention to that because there is some additional information in that cable referenced in the footnote. So I say, my Lord, that the Inner House was entitled to conclude that the impact of this measure on intra-EU trade, and I perhaps should have made the point, of course, we're talking about Scotland. It's only one part of the UK. But the Inner House was entitled to express the view, to reach the conclusion that the impact would be relatively minor. And of course, if I if I require to engage in a balancing, it would be my submission that 2,000 lives saved over 20 years and 38,000 alcohol-related hospitalizations saved outweighs a relatively minor impact on intra-EU trade.
I don't think there's any indication in the CJEU case law you have to undertake that exercise. I mean, they say it's a matter for the member state to decide on the degree of priority that it gives to, for example, the protection of public health.
Indeed, my lord. And what is striking is that although there are passages in the CJEU's judgment which might be taken to suggest that there is a balancing to be undertaken at the key passages, they articulate essentially a dual test. But I say that in a sense, I don't need to grapple with that particular question, and I appreciate that sometimes, and in Advocate General's opinions in particular, one sees that third stage being identified, and in other cases one doesn't. Here one doesn't see it clearly. But in any event, in this case, any balancing that would be required in my submission would clearly favour the proportionality of the measure.
It's not really that kind of proportionality issue. It's not a question of weighing the considerable impact on public health against the arguably minor impact on intra-community trade, because the real issue is whether a corresponding impact can be achieved by a different measure, so that, in a sense, both the impact on public health and the impact on free movement belong on both sides of the equation.
That's correct, my lord. Now, I should say I have no evidence about, in relation to the impact on trade of raising excise duty by 28%.
Yeah, but I mean, even if you did, it wouldn't actually get one closer to resolving the particular problem that is posed by the CJEU judgment, which is about different ways of achieving a corresponding objective, one of which, tax increases, would unquestionably have a lesser effect on intra-community trade, but may have side effects in other ways that are undesirable.
That's why I make the submission that the characterization of the aim is the starting point here. And it's on the basis of how one characterizes the aim that one can ask, are the alternatives as effective? Well, one can see that in the Advocate General's opinion. And I can give the court the reference. At paragraph 115, at MSO 373, he points out that it's necessary to identify the objective pursued in order to determine whether the measure is proportionate. And then there's a discussion. And at 120, he says that it will be for the national court to assess whether the measure pursues a twofold general and targeted objective or pursues only a targeted objective.
I mean, the Court of Justice, one potential criticism that one can levy against the analysis of paragraphs 47 to 9 is that the Court of Justice does not seem to have treated the impact on moderate drinkers as a question of degree. They seem to have treated it as if it was as important a measure to reduce their consumption as it was to reduce the consumption of the categories which were far more vulnerable to the health impact.
Yes.
So that the problem that I think is crucial doesn't actually seem to have been addressed in those paragraphs at all.
Right. Indeed, my lord. And it is perhaps important to recall that this measure is not seen as an alternative to excise duty. It's seen as one of our suite of measures in a strategy to address alcohol-related harm, which include, in relation to pricing, excise duty and minimum unit pricing, which on the analysis presented in the BRIA can achieve things in terms of targeting a particularly at-risk group, which a generalised increase in taxation cannot do. Yes. It is perhaps important, and perhaps this may be helpful, that after 47 and 48, we reach 49.
Well, there's 49, which says ultimately
It is for the National Court.
the National Court has to decide, although on what may be relatively incomplete assumptions, a pretty strong steer as to what they should decide appears in the two previous paragraphs.
Well, it's the National Court in 49,
Yes.
which is told that it has to ask itself
Yeah, absolutely.
whether a measure other than that provided for, such as increased taxation, is capable of protecting human life and health as effectively as that legislation.
Yeah.
I've made the submission that if one correctly understands what the measure is trying to achieve, what the aim is, and the reasons why a general increase in tax have been rejected, I say that, in a sense, 47 and 48 are missing the target, because it is not said we're not going to do this because it would save more lives. We're not doing it because it fundamentally doesn't reflect the particular target, the primary target that this measure is seeking to address, and the integrity of the balance that the legislature has sought to strike.
Is it clear what tests we're meant to be applying? Do we have to form a view that we think that it could be as well or better achieved by taxation? Or is it that the government, Scottish government, is entitled to take the view on the evidence that it would not be as well achieved by taxation?
It's the government and Parliament, I suppose.
So it is a judicial review type test?
I say that essentially for the reasons set out by the Advocate General, that judicial review should be marked by, he puts, a certain degree of restraint.
Yes.
That's at 82 and following.
It isn't a human rights type exercise where we carry out the balancing exercise.
I say it's a proportionality analysis, and appreciating that can be engaged in at a greater or lesser degree of intensity. This is a context in which a certain degree of restraint is appropriate. That's and
we throw into the balance, you say, in your favour, the sunset clause.
Indeed. The Advocate General points to three things.
Yeah.
First of all, that it's a matter for the member state to decide on the degree of protection and the way, importantly, that protection is to be afforded.
Yes, I mean, as you say, it's a separate point with the Advocate General is dealing with, but it colours the way we look at the evidence.
Yes.
When we're looking at the substantive issue that you're considering.
Indeed.
Does one not have to distinguish between, what we're talking about here is the margin of judgment.
Yes.
And I can see that there's an important place for the margin of judgment when you are comparing the relative importance of two potentially conflicting values. But if the question is, what will the actual consequences be? of a particular measure. It's a question of factual analysis, albeit a difficult one because it involves prediction. If the government reasonably but wrongly thinks that tax increases would not be as effective, it's very difficult to say that the result is compatible with Articles 34 to 36 of the treaty, isn't it?
Well, there's a lot implicit in saying reasonably but wrongly. How one gets to the but wrongly part of that.
Well, there's no real right or wrong if you're trying to decide which is more important, intra-community trade or health benefits. But there is a right or wrong, however difficult it may be to decide where it lies.
Well, I suppose
the questions we're concerned with.
There are perhaps 2 points I would make. The first is that the Advocate General, and in this respect he's reflecting a court authority, tells us that it is for the member state to decide on the degree of protection and on the way that degree of protection is to be achieved. And in the bundle, that's also said by the court in the Commission in Italy at MS 3130-1 at paragraph 65 and 66. And the second point he refers to in saying there should be a measure of restraint is that the assessments are complex and there is uncertainty about the outcome. And in that context, it would be my submission that the government is entitled to take our view with which others may disagree within a certain margin. It has to be and ultimately that margin is probably something one can only really test on a case-by-case basis.
Can I come back to the question what the tests which, whatever the margin, are, which have to be applied? Because, I suggested to you earlier this morning that one had to undertake a balance between two possibly competing values, and I think Lord Reid has just suggested that you don't. There may be a difficulty in construing the Court of Justice's judgment, but and it's partly perhaps because they were answered the question separately. But if you look at the answer to the first question, don't paragraphs 28 and 29 indicate that you have to undertake a proportionality test, difficult though it may be, which says, all right, you've got these legitimate objectives, maybe this is the only way of performing them, nonetheless you have to weigh the desirability of those objectives against the objective of the CAP and the proper functioning of the CMO. It says in the last sentence of paragraph 28, isn't it saying that? And again repeating that in 29? I entirely take my Lord's point. There are some difficulties of interpreting just what the court is saying. What is striking is that... It'd be quite surprising, perhaps, if one could simply set any legitimate objective and whatever the damage was irrelevant.
Of course, if one goes further back to 24 and 27, 24, 26 and 27, a measure that undermines the system may nevertheless be justified. And I appreciate there's a circularity in how one goes about the justification.
Right.
What's striking about the judgment is that at critical points, and one sees it in the ruling, and the ruling at 3.
Well, those are the other questions. That's why the trouble.
What one has it's framed as a dual test.
Yes, that's right. And 3 simply suggests you look at the objective and ask, is there any other way of achieving it? And if there isn't, that's where you stop.
Yes.
But that would be quite surprising, wouldn't it?
Well, Perhaps in the context of health, it might not be so surprising.
Yes, I see.
But as I said earlier, I don't, I'm quite content to meet any ultimate balancing for the reasons I outlined a moment ago. Perhaps I could just make this point, though, that one way one might be able to read 28 and 29 is if one's thinking about the less restrictive alternative part of the analysis, one has to ask less restrictive of what? And it may be that in the context of the CMO, and this is assuming you've got a measure that's equally effective, you then have to ask which does the least damage to the CMO. And that would certainly be our way in which one would be taking into account the objectives of the CMO as part of the dual test without an ultimate balancing. Now, I accept it's not the way it's said in 28, but it would be our way of, the objectives of the CMO necessarily come into the least restrictive alternative question, if one gets to that question.
Does paragraph 56 of the court's judgment support your analysis, where it's said that the court must in particular examine objectively, firstly, whether it can reasonably be concluded that the means chosen are appropriate, and then secondly, whether it's possible to attain those objectives by measures which are less restrictive. In one, they seem to be allowing a wider degree of discretion than in two.
I see that, my lord. If one looks at the Commission in Italy at 65 to 66, MS 3130 to 1.
Sorry, what's that MS number again, please?
Sorry, it's Commission in Italy
Yep.
at MS 3130 to 1, paragraph 65 to 66. It might be as well to bring it up, which is it's a Grand Chamber case.
I think this court analysed a huge number of cases of this kind in the Lumsden case.
Indeed, yes.
And I think Lord Hodge is, if I may say so, quite right, that what we inferred from reading a lot of cases was that the court allows discretion or a margin of appreciation to the member state in deciding, first of all, on the level of protection that it wishes to give to the relevant interests, such as public health, and secondly, as to the selection of a means to achieve that objective. But it then requires the court to apply the proportionality test. In other words, is there a less intrusive or less restrictive alternative available? Without applying that, without allowing discretion in relation to that matter. I mean, that's a matter to be objectively determined by the court.
Yes, but even if it must be, I suppose the selection of the way in which to achieve the end may itself include a consideration of alternatives, and we've seen that in the BRIA here.
Yes.
The document looks at the alternatives, forms our view, and I suppose the question is, in a context where there are uncertainties about what will happen with one option or another, is how hard-edged that decision-making by the court
Well, I think what I meant when I was talking about discretion in selecting a means, for example, there might be a lot of debate about whether, whether banning the open display of cigarette packets, for example, will actually result in a reduction in smoking. And it's that kind of assessment where you're trying to achieve an improvement in public health by through a reduction in cigarette sales, where the national government, or in this case the devolved government, is is allowed discretion in assessing what is likely to work, because that's a matter of judgment.
Yes.
So once it's made that decision, and the question arises, well, is there a less restrictive alternative which would be equally effective, then that's a matter for the court to determine on the evidence.
Yes. I suppose it's a question. There may be questions about evidence and the nature of evidence that one would rely on, how one would go about it. I say that it's my submission that in this case, the court doesn't have to get there, because I say there isn't an effective or as an effective alternative. That's my submission.
But in support of Lord Reid, you were referring us to Commission against Italy, and it is recognising in paragraphs 65 and 66 that the different member states can require different degrees of protection, and they can form a judgment on what rules are appropriate or necessary to achieve the legitimate objective. They don't go on to consider the second point, which the Court of Justice considered in the paragraph that I put to you, namely the less restrictive test. Would you accept that?
I accept that, my lord. I suppose it's subject to the rider that one also sees in the Commission in Italy, that the member state doesn't have to exclude positively every conceivable.
That's paragraph 66.
And 66 as well. But it's my submission that in this case, in a sense, that's a difficulty that doesn't have to be resolved.
Does should we focus further on Lumsden? I'll certainly read it.
It's this court's synthesis of the jurisprudence of the Court of Justice on issues of proportionality.
It is obviously less authoritative than the Court of Justice itself, but the passage, I had it in front of me, it's the paragraphs really 66 to 67 on MS 1606.
Yes. Well, I've sought to lay before the court some of the policy context and some, what I would submit, relevant factual material.
I mean, it would lead to the conclusion that if you form the view that a particular measure disruptive of the market would save one life and reduce 10 hospitalizations over a period of 20 years, provided you regarded individual life as sufficiently important, and provided there was no other means of achieving that saving without disproportionate disbenefits elsewhere, it was irrelevant that there was huge damage to the market. And I just find instinctively that it's unlikely that the European Court of Justice would take quite such a line.
Well,
and I think those paragraphs 28 and 29 point in a slightly different direction.
But
that, my lord, is partly why I'm. My basic submission on this is that in this case,
yes, it doesn't arise.
It doesn't arise because if there is a balance,
there's a significant saving.
There's a
really
significant saving. There's a serious public health, really serious public health problem, which my Lord Reid, my Lord Hodge, and
well, the court sometimes talks about a discretion. It sometimes talks about a margin of appreciation, and the margin is not unlimited.
Indeed.
And it is all, if you had some absurd suggestion that we would ban, would have prohibition for the sake of public health, then there would be a real issue as to whether that decision lay within the margin of appreciation of a member state.
Comes a point, I suppose, where the word legitimate becomes relevant, and you ask, well, can it really be legitimate if it does such damage to the market? You might get in the point coming in there.
Yes. Well, I say, my lords, that the starting point for looking at this question is the reasoning set out in paragraph 4.3 of the BRIA that I took the court to yesterday. And one can see reasons to the same effect in the policy memorandum at paragraph 29, MS 0799 to 0800. And one starts with the reasons that the government has set out for concluding that tax increases would not be effective in achieving the aim. And I might just make this point, that the issue is not considered solely by reference to excise duty. For example, consideration is given to a tax by reference to price, which would not be a basis which could be used in the context of excise duty. So there's an effort in those documents, at those passages, to look carefully at whether the aim, the particular targeted aim, can be achieved as effectively or at all by a general increase in taxation. And I say that when one attends properly to the nature of the aim, the conclusion drawn that tax on its own would not be an effective alternative was one which the government was entitled to reach and the Parliament was entitled to accept. And I come back to the point, it's the on its own part which is important, that this is a measure that is seen as complementary to excise duty. And I acknowledge that a tax increase could generate reductions in mortality and morbidity more or less equivalent. And if one raises tax far enough, then one can do that. The Sheffield study shows it. And as Lord Sumption anticipated, I say that that would be disproportionate for the reasons we've discussed. And I also accept that a floor can in principle be established by imposing a sufficiently high excise duty and imposing a prohibition on sale at a retail price less than excise duty plus VAT. And Table 6, which I referred to yesterday, which is not an agreed document, was an attempt to illustrate. It was an attempt to illustrate that on whatever the duty rates were at the time. But they really make the same point that I've made about proportionality. But I make the submission that the tax increase would not be as effective as minimum unit pricing in achieving the aim, not only because of that disproportionate effect on moderate drinkers, but because it simply doesn't reflect, a general increase in tax wouldn't reflect the targeted nature of the aim. It's a policy which seeks primarily to address the consumption of those in Scotland who are at the greatest risk of alcohol-related harm. It wouldn't, such an approach wouldn't respect the balance the legislature has struck. And one can add in that the measure is simple to apply. And there is a finding by the Lord Ordinary, not challenged, at paragraph 72, MS 0527, that for any given average price increase, concentrating price increases on the cheapest products is the most effective way of reducing total sales. So I say the key to this case is the proper understanding of the aim. Effectiveness has to be measured against that. And on that basis, the government and the Parliament were entitled to take the view that tax measures would not be effective. And I suppose there's just one other point about the 28% increase, which is, my learned friend suggested that it wouldn't be a good reason to say that that would be politically unacceptable. It's not a question of political acceptability or not, it's simply that it is so disproportionate, imposes costs so disproportionate to the targeted nature of the aim that it wouldn't be a realistic proposition for that reason. Yes. And I should make clear that in talking about the targeted aim, I'm not in any way resiling from the twofold nature of the aim. But it's important to read that twofold nature against the policy that underpins it, and to understand the primary target.
Would I be right, Lord Advocate, that there's been no examination by the government as to the effect of a 28% tax increase on EU trade?
No. Against that background, my lady, my lords, I say there is no error in the judgments of the Lord Ordinary or of the Inner House. I invite the court to read the opinion of the Lord Ordinary. The only point taken by Mr. Neal was in relation to the final sentence of paragraph 80 at MS 0529 to 30. There's right at the end of paragraph 80, there's a sentence, the level of protection of health and life imposed would be greater than that thought by the Parliament and the ministers to be appropriate and proportionate. I invite the court to read that sentence against the whole analysis that the Lord Ordinary sets out. He correctly articulates the aim at 53 to 54, and from 61 onwards addresses necessity. He looks at the BRIA. He makes a variety of observations, including the one I mentioned a moment ago. He makes the point at 73 to 74 that targeting is not possible in the sense of focusing duty increases on cheaper alcohol. And at 79, he makes the point about striking a balance. And at 80, he makes the point that raising taxes would produce a materially different outcome. And I say that against that, one reads that final sentence against that whole background. And essentially what he's saying is that
Well, he should be adding at the cost involved. I mean, obviously, in a sense, any increase in protection of health is a good thing, but
indeed,
if it costs you £1 million, it may not.
Indeed. I say one reads that sentence in context. Read in context, it's not erroneous. If it is, it's not a material error. So far as the Inner House is concerned, my learned friend identified two errors in oral submissions yesterday. He first of all contended that the First Division redefined the aim of the legislation. In my submission, that's not correct. The court below addressed the aim at paragraphs 171 to 172. at MS 0305-6, and there is nothing in those paragraphs that is objectionable. He referred to passages where the court referred to hazardous and harmful drinkers in poverty at paragraphs 181, 204 and 206. And in my submission, all those passages are descriptively accurate. They don't suggest that the Inner House has misunderstood the aim of the legislation. And he criticised them also for characterising, in his words, tax as a blunderbuss and unit pricing as a rifle. And I say that that criticism is misconceived, essentially, for all the reasons that I've already outlined. And I come back to the point that these are not alternatives, they are complementary tools in addressing price as part of an overall alcohol strategy. And minimum pricing is particularly useful to raise the price of alcohol, which is cheap relative to its strength, to ensure that the price, to ensure that a floor is fixed to the retail price, and thereby to address those consumers who are most at risk of alcohol-related harm. Before I just draw the threads to a conclusion, there is a legal matter I need to address, which is excise duty and Article 1(2). The proposition that excise duty rates require to be set across the whole territory of a member state is based on provisions in Directive 92/83 EEC, which is at MS 4423, Authorities tab 71. That directive envisages that in relation to each category of alcohol, the member state will fix a rate of duty, and then there are specific provisions which permit reduction of the rate in particular circumstances. And in relation to all categories except beer, the directive requires member states to charge the same rate of duty on all products chargeable with the duty. And that's Article 9(2), 13(2), 18(2), and 21. But I should say immediately that I accept that Article 1(2) of the directive at MS 4457 could be applied in relation to only a part of the United Kingdom, and that would permit the United Kingdom to levy an indirect tax on excise goods, provided it satisfies the requirements of that article. And I should say I don't read the concept of a hypothecated tax quite as narrowly as my learned friend did. If one looks at the case to which he drew attention, the Transporters Yordi case at paragraph 32, MS 4339, the court tells us that a tax could be regarded as pursuing a specific purpose, not only if the revenue is allocated to the specific purpose, but also if it is designed, so far as concerns its structure, in such a way as to dissuade, or on the other hand, encourage consumers to act in a particular way. And so I accept that it is entirely appropriate to test the issues in this case on the basis that a supplementary excise duty specifically for Scotland could be established, provided it's configured in a manner which satisfies the conditions of Article 1(2). That, of course, it would still be a matter for the United Kingdom to consider, because tax and excise duty, except specifically devolved taxes and local taxes, are reserved to the UK. But I accept that that doesn't affect the EU analysis, for the reason that my Lord Sumption gave yesterday, that one cannot rely on the internal constitutional arrangements of the country to justify a breach of EU law. In practice, if the Scottish Government were to consider that a tax or excise duty option was the appropriate option, it would engage in a dialogue with the United Kingdom Government to seek legislation at the UK level, or indeed a Section 30 order under the Scotland Act, which would give the Scottish Parliament power to introduce such a measure. And I agree with Mr. O'Neill that there's nothing in that the 1707 legislation would not prevent the creation of a specific taxing power under Article 1(2) of the directive. So, long story short, I accept that the testing of this particular measure against the hypothesis of an excise duty or a supplementary excise duty specific to Scotland is an appropriate hypothesis to use. Yes. Two other corrections to my case. First of all, Mr. O'Neill was correct about the exemption for craft beers. And the other one is in relation to the opening sentence of paragraph 1.1, right at the start of my case, at MS 0166, which states that in these proceedings I represent the Scottish Government. That's, strictly speaking, an incomplete statement. In relation to the challenge to the Act of the Scottish Parliament, I'm exercising the particular function identified by Lord Nimmo-Smith in Adams and Scottish Ministers at 2003 session cases 171 at paragraph 31. In relation to the orders...
Say that again.
It's a particular law officer function.
You have to say it distinctly.
I do beg my Lord's pardon. It's Adams and the Scottish Ministers, 2003 session cases 171 at paragraph 31. And it's effectively the point that an act of the Scottish Parliament is ultimately an act of the Crown granting royal assent to a bill. And I am the appropriate law officer to defend the statute book, whether it's a government bill or a non-government bill. As it happens, this is a government bill. In relation to their orders in the petition, which seek to restrain the Scottish ministers from making various orders under the Act, and I plainly appear on behalf of the government in relation to those. So with those corrections to my written case, I can perhaps just draw the threads together. That no error has been, in my submission, made out in the opinion of the Lord Ordinary or of the Inner House. And on that basis, the appeal falls to be refused. And I should just, perhaps for completeness, make this very short point, that the appellants have submissions in their written case that the Scottish Government has not satisfied the evidential requirements of EU law. My learned friend didn't touch on these in oral argument, but in my submission they fall to be rejected. The BRIA, in my submission, satisfies the requirements set out at paragraph 54 of the Court's decision. While it didn't address the CMO as such, it did consider the effect on wine consumption, and it's been supplemented by a substantial body of material from which the lower courts have been able to draw conclusions which justify the measure. So unless there is anything further that I can do to assist the Court...
But if I could just raise one matter.
Indeed, my Lord.
It hasn't been discussed so far at this hearing, and if nobody is raising the issue, then I will drop it. But let me just mention it. the effect of the MUP that's of concern to the European authorities is that it affects competition, because it is liable to affect the ability of a lower cost producer to take advantage of his lower costs in the market in which he sells his products. And of course, Article 34 isn't a competition law provision at all. But the Court of Justice in their judgment in this case explained how a distortion of competition can affect trade between member states in paragraphs 21 and 22 of the judgment. Now, of course, excise duties can also affect trade between member states. And so the court says at paragraph 46 that a fiscal measure which increases the taxation of alcoholic drinks is liable to be less restrictive of trade than a measure imposing an MUP. But that's by no means a necessary truth. It might not be.
That's certainly true, and if one's envisaging an increase in excise duty of 28%, I have no evidence on that, and I face up to that. But it simply is a matter of perhaps basic economics. It's likely to have an effect.
Well, clearly, I mean, that's the point I was wanting to raise. That there will come a point, depending on how the MUP is fixed, and how much tax would have to rise in order to have an equivalent effect. But there will come a point at which the effect on trade of the tax rise would be greater than the effect of the MUP. The effect on competition wouldn't be the same, of course, but that's not what we're concerned with directly here. And I'm just wondering if that aspect of the case has been thought about.
That was essentially why I asked the question.
Yes, I mean the short point is I've got no evidence on that. I think.
Does it come back to what the Lord Ordinary said in paragraph 65 of his opinion, where he says the respondents had the opportunity to show that the consequences for free movement would be different from those that the petitioners maintained would result? They haven't availed themselves of that opportunity. Is that really... You haven't looked into the effect of tax on free movement?
We certainly haven't taken the 28%. I mean, there is a comment, but at paragraph 71 of the Yarrow and Decker report, which just makes the observation that the price increase might, for aught yet seen, be the same, or words to that effect. But that's simply a sentence in a report, and so my Lord is right. I mean, one can't assume it to be axiomatically true that the impact on trade will necessarily be less with a tax at the level required. But I don't have an evidence base to take that any further.
Well, any significant reduction in consumption, which will normally be the effect of a price rise, however generated, will, in a sense, affect intra-community trade in a commodity, a significant proportion of which is imported. But the effects that one is primarily concerned with are the unequal or potentially unequal impact on different products, potentially manufactured by different people in different countries, of some ways of taxing alcohol. It seems to have been assumed, I would have thought correctly, that an excise which is directly proportionate to value and applies on a common basis to everything, except insofar as the directive regulating excise provides for a difference, would not be as intrusive on that.
The interesting thing is the excise duty regime doesn't tax on the basis of value.
Well,
VAT taxes on the basis of
well, exactly.
price.
Well, it is a tax on value within categories, but the differences between the categories mean that there is an EU law authorised difference.
Yes.
So we don't worry about that.
Well, but it's simply the point that, for example, with spirits, it's a tax based on alcohol content.
Yes.
And for the other categories, the different approaches to calculation set out, but not price. So I don't think I can take my Lord Reid's question really any further. So unless I can assist the court, those are my submissions.
Thank you very much indeed, Lord Advocate. Mr. Moynihan.
Lord, ladies, and lords, I have nothing to add.
Thank you very much. Mr. Simpson.
My Lord, my Lady, and my Lords, as thank you. Set out in my written case on behalf of the second respondent, the submissions I propose to make concern solely the proper approach in law to the issues before the court. I do not seek, on behalf of the second respondent, any particular disposal of the appeal. I refer generally to my written case and adopt it. And what I propose to do is simply to speak to some of the issues that are set out in it, without taking your lordships and your leadership through it in full. The first issue that arises is indeed which issues arise. And there's some dispute between the parties as to whether there are issues as to the necessity to identify an error of law and what deference must be shown, if any, to the legislative body that enacts the provision being challenged. In my submission, both of these issues arise out of the appellant's grounds of appeal. The first ground of appeal I take from the paper apart to their notice of appeal, which is at MS page 42.
Yeah.
Ground of appeal number 1 is entitled that the First Division restricted its role to review of the Lord Ordinary's decision. At paragraph 1.1, there is set out what the First Division says at paragraph 113 of its opinion. And at the end of that, quote, the Lord President says that, returning to a theme developed earlier, it's important that the appellate court does not attempt to rehear the entire case, as seemed to be implied by some of the submissions, as if it were a court of first instance. The appeal is circumscribed by procedural rules and practices confining the scope of the review of the Lord Ordinary's decision within reasonable bounds. The complaint that's made in paragraph 1.2 is that in making the foregoing observations, the First Division reached its judgment on the basis of confining itself to the question of whether the judge at first instance erred, rather than by satisfying itself that the Scottish ministers had, on the basis of the most recent evidence available to the court, demonstrated that the legislation was proportionate.
Now, of course, in my submission, that is indeed what happened, but had the First Division identified an error in the Lord Ordinary's opinion, one might have expected it to go on and consider for itself whether the Scottish Parliament had acted in compliance with EU law. At paragraph 1.4, the complaint is made that the approach which was taken by the First Division when the reference was received back from the CJEU was an error of law, and that is on the basis of the approach the First Division took of acting as a review court. I do note that, as the Lord Advocate just mentioned in his oral submissions yesterday, my learned friend Mr. O'Neill did seek to identify errors of law by the Lord Ordinary and the First Division. What it's worth in my submission, it was not terribly clear whether they were said to be necessary by my learned friend Mr. O'Neill in order to succeed in his appeal. But I wouldn't propose to say anything further about that. So far as the second issue is concerned, again, I refer to the notice of appeal at the same paper part, MS page 51. In ground 5, excessive deference to the position of the Lord Advocate and the lack of material to support that position. There is set out an excerpt from the opinion of the First Division that it's for the state to decide on the level of protection of health and life, taking into account the principle of the free movement of goods. And then another excerpt said to be different, approving the formulation of Lord Ordinary to the effect that it was for the state to determine the level of protection and the way in which it was to be achieved. Now, as has been discussed already this morning, the case law of the Court of Justice does indeed say that the member state has a discretion as to both facets, both those facets, namely the level of protection and the means to be used to pursue it. But in any event, the appellants in Ground of Appeal 5 continue by suggesting that the state's ability to set any particular level of protection is limited by the treaty, and in particular the requirements of the free movement of goods. And then at the end, in the second half of paragraph 5.5, it turns into the question of whether, even were there such a margin, it could not extend to permitting the choice of a measure which restricts the free movement of goods over a measure which can at least as effectively achieve the health objective with no or much less impact on free movement. In my submission, that's a reference to the issue that has come to be of some importance, namely whether the Court of Justice's reference to whether it can reasonably be concluded applies not only to the first limb of the proportionality test, but also to the second limb of that test, and whether there is a less restrictive means by which the same result can be achieved. That's a point to which I'll return in some detail. But for the moment, my point is that both of the issues that I submit do indeed arise, and arise out of the grounds of appeal. It's not clear the extent to which the appellants still insist on all their grounds of appeal, but in my submission, the approach that's been taken by the appellants seems to assume success on both of those grounds, in that from the very start, my learned friend asked the question, why not tax? And made submissions on the footing that that was a question really at large for the present court, and one did not have to delve into the decisions of the courts below, or give any particular deference to the legislative body. In my submission, that is not the correct approach that should be taken by the present court.
Yes.
Now, I turn now to the first of those issues. I set out my submissions at page 203 to 207
Yes.
of my written case.
Yes.
As mentioned, I adopt that and would simply emphasise the reference in the Court of Justice in paragraph 64 of its judgment.
Yes.
That the member, the court's task is to take into account the information, evidence, or other material of which it has knowledge, but under the conditions laid down by national law. Now, that was, of course, in the context of reference made by an appellate court. The Court of Justice did not say anything in particular in terms of an obligation on an appellate court to go beyond a review of a court of first instance. In my submission, national rules restricting the function of an appellate court for perfectly good reasons to, in the first instance, a review of a lower court's decision are recognised here by the Court of Justice as compatible with European law as a generality. Of course, European law does set limits on what national procedural rules may do, for example, by regard to the principle of effectiveness or the principle of equivalence. But there is no challenge, at least as far as I understand in the present case, to the rules set out by the First Division as regards the role of an appellate court, both in terms of allowing additional material to be put before it beyond that available to the Court of First Instance, and in terms of its role as a review body having first to consider whether the Court of First Instance made any error of relevant error before going further and, if appropriate, considering the case more generally. That is an approach that has since been followed in the England and Wales by the Court of Appeal. Of course, in the case of the Queen and the application of British American Tobacco Limited, and I set out the relevant passage of the judgment of Lord Justice Lewison at paragraph 20 of my written case, yes, on page 206 of the memory stick, the MS page 206. In that case, of course, the tobacco company sought permission to appeal to this court, but permission was refused, of course, by a panel including my Lords Mance and Lord Sumption. So on that first ground of appeal, my submission is that it should be refused, and that the present court should, as the Lord Advocate has also indicated, first consider whether, in particular, the Lord Ordinary made any error, and if the Lord Ordinary did not, then the appeal is refused on that basis alone, without the need to go into any more general assessment of proportionality, for example. I turn then to the rest of my written case. I set out separately submissions on deference to the legislative body and the approach to proportionality, but I don't propose to go through them in detail, but to make instead some submissions on the basis of the case law, and in effect take those 2 points together. I would begin by emphasising that so far as a proportionality generally is concerned, the Court of Justice said that there is no need for a separate exercise between Article 36 in the present case on the one hand, and the proper operation of the CMO on the other. And certainly my other friend, Mr. Neal's submissions yesterday, he didn't seem to suggest there was, he didn't seem to treat them separately. As my Lord Reid mentioned earlier this morning, the present court has set out in some detail an analysis of proportionality in the case of the Queen and the application of Lumsden against the Legal Services Board. And if I might take your Lordships and your Ladyship to that. The judgment in Lumsden begins at page 1575.
Yes.
It concerns, of course, a regime for qualifications on counsel appearing in criminal courts.
Which bundle is that in?
Sorry?
Tab 7.
Tab 7.
Sorry, Lord, it's
It's all right, I've got the answer.
it's tab 7 in part A of the
Yeah.
authority.
I mean, we don't need to go through, which passages do you rely on? Because we're concerned with principle, aren't we?
Lord,
Lord Reid referred to 66 and 67 in argument with the Lord Advocate.
yes, my Lord. In fact, 66 and 67 are the most important ones at page 1606.
Yep. Yes.
Before that, I would emphasise page 1604, paragraph 60. There's reference to the fact that it may well be relevant to proportionality to consider whether a measure in question is subject to review in the light of experience, and that's obviously a factor in the present case. Paragraph 63 at page 1605, it is said that the less restrictive alternative test is not applied mechanically. So, for example, the member state needn't exclude hypothetical alternatives. And at paragraph 64, there's a reference to the Court of Justice having accepted where relevant public interest is engaged in an area where EU law has not imposed complete harmonisation. The member state possesses a discretion or a margin of appreciation, not only in choosing an appropriate measure, but also in deciding the level of protection to be given to the public interest in question.
Yeah, then we have
Then, Paragraph 66.
I mean, there's no dispute, Mr. Simpson, that there is an element of discretion in relation to the choice of measure and the degree of protection.
Yeah.
The issue is simply whether, when you get on to the second question that is posed, whether that's a matter for the court or the court is simply reviewing what the legislature has done.
Yeah.
Yes, my Lord, and what is said in paragraph 66 is that the margin of appreciation applies to the member state's decision as to the level of protection and to the selection of appropriate measure. Having exercised its discretion, however, the member state must act proportionately within the confines of its choice. A national measure will not therefore be proportionate if it is clear that the desired level of protection could be attained equally well by means which were less restrictive of a fundamental freedom.
What's the authority for the first sentence or the second half of the first sentence of paragraph 66, that the margin of appreciation applies to its selection of an appropriate means? Because it's formulated differently in the present judgment. I know you're going to come to that, but that's the argument against you.
Yes, well, my Lord, in the first, it is clear that there is a margin of discretion of the appropriate means.
Yeah.
That's, for example, omitted by the Court of Justice in its judgment in Scotch Whisky, but, for example, appears in the subsequent case of Deutsche Parkinson.
Also, perhaps the passage that's quoted in paragraph 64 from a Politikerkammer, it's for the member states to determine the level of protection which they wish to afford to public health and the way in which that level is to be achieved.
Yes, yes, Lord. And so one can see it in previous case law as well, and one can see it in the subsequent case of Deutsche Parkinson.
Yep.
So, yes, perhaps this is a different point from the point we've got to get on to, as to whether the margin applies in relation to alternative objectives. Is that right?
Possibly more, but certainly
I mean, whether it's possible, there may be there obviously is a choice which member states make as to what means to adopt, but when you're judging whether the objectives could be obtained by other means, that's what we're focusing on, isn't it? And whether that is something where there's a margin or not.
yes, more, and what is the statement here is that if it is clear that the desired level of protection could be attained equally well by measures, then one cannot, the measure that's been used is not proportionate. But in my submission, it's that test of whether it is clear that implies that the second limit of the proportionality test does allow a member state some discretion on the basis that if the member state is reasonably entitled to conclude on the basis of the evidence before it that the alternative measure is not less restrictive or not equally suitable to achieve the means in question, then the member state is entitled to the measure that it has chosen. In other words, if the member state reasonably concludes that the second limit of the proportionality test isn't satisfied, then it can't be said to be clear that the other measure or that the desired level of protection could be attained equally well by measures which were less restrictive of fundamental freedom.
Well, it's not what Rosengren says. Paragraph 43 of Rosengren doesn't have the formula, if it is clear. just says a national rule or practice cannot benefit from the derogation provided for by the treaty if the health and life of humans may be protected just as effectively by measures which are less restrictive of inter-community trade. It seems to be just a sort of flat statement which leaves it open.
Yes. Yes, my Lord. And it may be said that so far as I can make out, in all previous cases, the Court of Justice has not distinguished between the two limbs of the proportionality test. In previous case law, it has used the same language in relation to each, without using this concept of whether it can reasonably be concluded that the means in question is suitable. In my submission, the explanation for that is that in the present case, the Court of Justice was expressly asked about intensity of review, and it put forward this formulation in relation specifically to that question, but not in the context of other answers, about whether it could reasonably be concluded that the proportionality test was met.
Are you going to go to paragraph 59 and analyse it?
Yes, my Lord, I can do that right now. Paragraph 59 appears at MS page 340. It's the paragraph that is at the end of the Court of Justice's consideration of the fourth and the sixth questions. In paragraph 53, for example, the Court of Justice on page 339 uses what may be called the usual formulation. It's for national authorities to demonstrate that the legislation is consistent with the principle of proportionality. And it may be pointed out that the Court of Justice there identifies the principle of proportionality as a unitary concept. National authorities have to demonstrate consistency with that principle. That is to say that it's necessary in order to achieve the declared objective, so that's the first limb, and that objective couldn't be achieved by prohibitions or restrictions that are less extensive or less disruptive of trade, and that is the second limb. And no distinction is drawn there as regards intensity of review. The Court of Justice then considers a number of points, in particular the lack of any need to prove positively that no other conceivable measure could enable a legitimate objective. Paragraph 56, it's for the National Court called on to review the legality of the national legislation, and then on the basis of relevant evidence adduced, and on the basis of that evidence, it must examine objectively whether it may be reasonably concluded from the evidence that the means chosen are appropriate and whether it's possible to attain those objectives by measures that are less restrictive of the free movement of goods. Yes, one can see that in one particular linguistic analysis of that sentence, one gets to the conclusion that somehow the second issue is one of right or wrong, the first issue is one of entitlement.
Yes, two separate questions, and in relation to the first, there's the reasonable conclusion criterion. In relation to the second, there isn't.
Yes,
why is that wrong, and why is that inconsistent? That interpretation wrong? Why is it inconsistent with what this court has said in Lumsden?
Lord, my submission is that the reason why the court brings in at this stage, and hasn't done so in previous cases so as to distinguish between the two limbs, is that in this case there is significant uncertainty about the consequences of either any of the possible measures. Uncertainty, first, as regards whether a measure is suitable to achieve the outcome in question. So, for example, in the present case, whether the minimum pricing will achieve a reduction in deaths, or how many, what sort of reduction it will achieve, and indeed what sort of distortions it may create on the market. That nature of uncertainty equally applies to the consequences of any of the other measures that may be put forward as an alternative. As far as those other measures are concerned, they of course only fall to be considered in the second limb of the proportionality test. And in my submission, it would be inconsistent to allow suitability to be the subject of a review so far as the enacted measure is concerned, but not to be the subject of review so far as alternative measures that have not been acted are concerned.
I mean, your point is, whatever the formulation, if they accept uncertainty in relation to the measures actually adopted, why aren't they accepting uncertainty and therefore a test according to what reasonably appears from the evidence in relation to the measures which haven't been adopted, which are being proposed as alternatives?
Indeed, my lord, indeed.
But I mean, you do accept that linguistically it means exactly what Lord Hodge put to you.
Yes, linguistically, it certainly can be read in that.
Well, I've looked at other language versions, and it's quite clear on them that it's weather, or in German, ob, and
yes,
in Spanish, see, and the French is different, but it's the same effect. I mean, there are
yes, I've likewise looked at the other language versions, and they are certainly similar. The German and Dutch, in particular, are consistent with this. But in my submission, the approach to interpreting what the Court of Justice says is really not to focus so closely on a linguistic analysis, but to look at why it is saying what it is saying. In this case, no distinction has been drawn in any previous case by the Court in relation to these two limbs of the test. If the Court were deliberately intending to draw a distinction in Scotch whisky, one might have expected it to expressly say so and to explain why it was doing that distinction, instead of rolling them into the same sentence as it has done.
Yes, but it can be put against you that really the first part isn't much of a concession to member states because of the prior words which govern both halves, namely examine objectively. So, I mean, the Court is required to make up its mind under all language versions by examining objectively the evidence. And whether it may reasonably be concluded doesn't mean whether it may reasonably be concluded by a member state, it's whether it may reasonably be concluded by the Court, isn't it?
Yes, but that is correct.
So
but nonetheless,
the truth is, you don't get much from the. You always judge cases on the evidence, and the question is what the Court can reasonably conclude from the evidence. Probably under both heads or limbs.
Well, in a situation of uncertainty like the present, the question is whether one is entitled reasonably to conclude that these two tests are satisfied. And in my submission, I would suggest that in neither in neither stage is there a right or wrong answer. In fact, when one's in a forum of uncertainty such as the present, one thing one can be certain about is that none of the analysis will turn out to be correct. That's the nature of forecasting in these sort of fields. And that the actual outcome of one or the other may be closer or further away from whichever forecast one particularly looks at. But in my submission, it's not a case where there can be any right or wrong. One cannot say that one particular forecast is right. One can say whether it is a reasonable, whether it's reasonable to conclude on the basis of the forecast that a measure is suitable, for example, whether that measure is the one enacted or the proposed alternative, and whether the one or the other is less restrictive of trade. Because again, the question of less restrictive of trade is also an issue involving uncertainty, and there is no reason in my submission, either in policy or in principle, and certainly none put forward by the Court of Justice, to suggest why a different approach should be taken to those same questions that must be asked of the different measures under consideration. So, as mentioned, there is no case law in which the Court draws any distinction between the approach to these two cases, and the particular linguistic analysis of this sentence in my submission, in the absence of any good reason, policy or principle, to draw a distinction is not enough to reach the conclusion that a different approach is required in relation to the second leg than is required in relation to the first leg. That's all I would say on that point.
Right.
The next point I want to mention is just to emphasize the Court of Justice's statement or decision in Commission against Italy, the motorcycle trailer case, that member states are free to choose general and simple rules over complex rules that are difficult to enforce.
Which case is that?
Commission against Italy.
Right.
It's at tab 40.
That's the one about motorcycle trailers.
Yes.
Banned on road safety grounds.
Yes.
Yes.
Surprisingly.
It begins at page 3089 of the memory stick. But the passages I would like to look at begin at page 3129. 3129. Again, so at paragraph 59, one has, as I mentioned, the usual statement by the court that prohibitions, in this case on free movement of goods, the import of motorcycle trailers, may be justified on public interest grounds set out in Article 30. And in either case, the national provision must be appropriate for securing the attainment of the objective pursued and not go beyond what is necessary in order to attain it. So there is another instance of the court not distinguishing between these two limbs of proportionality test. At paragraph 65, on page 3130, the court sets out that the member state is entitled to determine the degree of protection which is to apply, and the way in which that degree of protection is to be achieved. At paragraph 66, again, it's for the member state to demonstrate that its rules are appropriate and necessary to attain the legitimate objective being pursued. Again, no distinction drawn between the two limbs. That the burden of proof can't be extensive so as to require the member state to prove positively that no other conceivable measure could enable that objective to be obtained under the same conditions. And finally, at paragraph 67, although it's possible in the present case to envisage that measures other than the prohibition laid down by Italy could guarantee a certain level of road safety for the circulation of a combination composed of a motorcycle and a trailer, the fact remains that the member states can't be denied the possibility of obtaining an objective such as road safety by the introduction of general and simple rules which will be easily understood and applied by drivers and easily met and supervised by the competent authorities. So in other words, in assessing, in the present case, for example, what is, in my submission, undoubtedly a general, simple, clear and easy to enforce rule, such as minimum unit pricing, the court could take into account any complexity or difficulty of enforcement of the alternatives put forward by the appellant.
Yep.
Finally, I would mention briefly the last point I've discussed in my written case, which is proportionality stricto sensu, whether there is a third limb to the proportionality test in the present case.
Which paragraph?
Sorry?
Which paragraph of your case?
In my written case, sorry, Lord, it's paragraph 58 following page 217 of the memory stick. As Lord Advocate submitted, in my submission, the key passages of the Court of Justice's judgment, in particular paragraphs 53, 56 and 59, do not refer to a third stage that has to be considered when working out whether the test of proportionality is met. In my submission, as I mentioned, that's appropriate in a case such as the present, at least, where the two interests in question are, on one hand, the lives of individuals, and on the other, the financial profits of companies and other persons. That's archetypally, in my submission, an exercise that's for the elected legislative body to undertake. Although on the basis of learned from Mr. Neal's oral submissions yesterday. I'm not entirely sure whether any point is being put forward that at that stage, assuming minimum pricing to be a suitable means and there to be no less restrictive means available, minimum pricing would fail to meet that test. Unless I can be...
Well, just help us. It's all very well to refer to paragraphs 53, 56 and 59, which are, as you say, dealing with the matter without referring to a general test, but what about paragraphs 28 and 29? In paragraph 28, they point out in the first sentence that they're going to confine themselves in the later paragraphs to dealing with the two questions which the later paragraphs deal with. They say that is measure appropriate for obtaining the objective pursued and mustn't go beyond what's necessary. But then you've got the sentence, it must be observed that in any event the issue of proportionality must be examined by taking into consideration in particular the objectives of the Common Agricultural Policy and the proper functioning of the CMO, which necessitates that those objectives be weighed against the objective pursued by that legislation, namely the protection of public health. So somehow we've got to fit that into the later answers, or fit it into the scheme on the face of it, and they repeat that in 29.
Yeah, yes,
I mean, it may all be very obscure, but it's not helped by if one just ignores this passage.
No, but it's not terribly clear what the court is driving at in paragraphs 28 and 29.
I mean, the Lord Advocate ultimately was not minded to quarrel on this, but I think you're taking a firm point of law and saying that we just stop at the analysis in paragraph 55, 59 and 56, which seems to be difficult in the light of the introductory paragraphs here.
Yes, Mark. Well, my submission is, of course, that those objectives of the CAP, the CMO, and indeed free movement of goods have to be considered in the context of the proportionality assessment. In the second limb, in any event, because one has to ask a question as to whether there are less restrictive means available. So it may be that the court is simply pointing out that those are the objectives that have to be considered when one is asking less restrictive of what? Free movement of goods on the one hand, or the proper functioning of the CMO on the other. Because there's all sorts of other things that may be taken into account, less restrictive of individuals' rights to purchase alcohol at a particular price, less restrictive of individuals' opportunities to purchase wine at one price point instead of some other price point, and so on. So certainly, in my submission, these objectives do indeed have to be taken into account in asking the question in the second limb, less restrictive of what? In my submission, if one does look to those later paragraphs, 59 in particular, this is answering the fourth and sixth questions, which one can see from paragraph 51, concern the extent of the review of proportionality, without any limit on what part of the test or the scope of the proportionality review. In question, it's simply the whole of the issue of proportionality. What is the intensity of review that one undertakes in relation to proportionality as a whole? The answer in 59, page 340, is simply that one has to examine objectively whether it may reasonably be concluded from the evidence, and leaving aside issues about whether that applies to the first or second limb. One, whether the means chosen are appropriate for the attainment of the objectives pursued, and two, whether it's possible to obtain those objectives by measures that are less restrictive of the free movement of goods and of the CMO. So one sees here the court expressly bringing in those two concepts, but only as part of the second limb of the test. And in my submission, that's how one can square the circle, reconcile what the court says in paragraphs 28 and 29 with what, in my submission, the key passages in paragraphs 59.
Thank you very much.
So, my Lords, indeed, unless I can be of further assistance, I would finish my submissions here. May I say finally that this has in fact been my first appearance before the Supreme Court, or indeed the House of Lords, and it's been a privilege to be able to address you in this case.
Thank you very much indeed. Thank you, Mr. Simpson. Mr. McGregor.
My Lords, I have nothing to add.
Mr. Simpson, it may be your first case, but you have timed your ending of your submissions extremely well. Thank you very much.
Right.
My Lords, in terms of timing, we've prepared a note of our responses to what's being said. Co-counsel and myself have been working very hard on this. It might save time. We're happy to hand it up at this stage. It certainly structures where
Well, we won't promise to read it, but there's no harm in that. There's no harm in having it.
What I can promise to do as a result is keep within the time I have, and we will be finished early today.
Well, that's very helpful.
And it will, of course, be helpful to your opponents also to see it.
Of course, absolutely, and they will be given it too before lunch.
Very well, we will take them away with us and bring them back with us.
Well, I think I shall actually read it.
The usher will get them now and will give them to us outside. Thank you very much indeed. We'll adjourn now and resume again at 2 o'clock. Thank you.